Hey, everybody, this is John Weslowski with the CT team, co-lead agent with Baird and Warner. And we're going to bring you some good information today about two different topics. One is regarding title, how you own your home with title. So that'll bring you some good information today. I'm in Naperville, Illinois, Baird and Warner. We also serve surrounding areas like Lisle, Aurora, Downers Grove, Plainfield. I'm here today with attorney Steve Shaykin, and I'll let Steve introduce himself, and then you can see my number there if you need to contact me with any questions. I can also be reached at 630-222-9747. That's my direct cell phone. And if you have any questions after the show. So Steve, why don't you introduce yourself, and then we'll get into the topic.
Hello, everybody. I am very excited to be here with my friend John to discuss pertinent topics for consumers that are looking to buy or to sell. My name is Steve Shaykin. I have been an attorney for a long time, and as John and Christine do, I go almost anywhere for the transaction, and I'm here to assist all the way through from beginning to end. So today's topic is title. Title is ownership. Title is a fancy legal word for ownership, and you hear it bantered about. First, I want to get rid of a myth that's out there. There is no document or piece of paper called a title. Okay, everyone gets confused with the fact that there is the title to your car, but that's really not that document. If you look at that document carefully, what it says across the top of it is certificate of title, which in other words means certificate of ownership. And cars are handled one way, real estate completely different. So we use a deed to transfer ownership to real estate. Deeds transfer title. Title is an invisible bundle of rights that you can't see. There is no document, but everybody confuses the deed with, oh, this is my title. Well, it is the document that gave you title, and it gets recorded to show that you own it, but it isn't title itself. Okay, enough of that. So things about title that are interesting. Title can be in a legal entity like a corporation or an LLC. A lot of people that are invest in real estate and have rental properties, they put their properties into those type of entities for liability protection. And when you're selling those properties, you now have to verify some things. One, does the entity still legally exist? Is it current with whatever state it was formed in? And you have to show some documentation to show who is the living person that has the authority to sign documentation on behalf of that company. Because you may know that it's your company, but no one else necessarily knows that. So you have to produce additional documentation saying that, Mr. Jones is the president of ABC Incorporated and has the ability to sign for that entity. When it comes to trusts, there are more simplified trusts that are referred to as land trusts. A lot of people have their properties in a land trust. I recommend land trusts all the time because they make it simple for when people pass away, that the ownership can move simply through the trust and you don't have to go through the process of going to court to get the ownership taken out of the deceased person's name. So when you have the property in a land trust, whoever the named land trustee is, and typically especially when you deal with, if I'm involved, Chicago Title Land Trust Company is where I do all my trust work through. And then we have to get the deed from the trust. That's where title, the ownership, is technically in the name of that trust. It is not technically in the name of the owner, although the owner wouldn't recognize the difference because they have total, complete control over the property and can do whatever they want with it. And they get all the proceeds from the sale, if there is a sale. But
I have a couple questions. What are the most common ways that people own their home with regard to title? Like your typical person may own it just in their name, but what percentage of people own it in a trust?
Well, with all due respect to the folks out there, the people that are forward thinking and are looking to protect themselves have their property in a trust. But the most common way for a married couple to own their home is as tenants by the entirety. And the beautiful thing about that is it has an automatic right of survivorship between the spouses. So if, heaven forbid, one of the spouses passes away, the moment that spouse passes away, by law, by the way it's owned, the property is 100% owned by the surviving spouse. So that makes it easy in the event of a tragic event that someone has passed away. That property can be sold. All that's needed is a death certificate to establish verification that that person has in fact passed away. Another very, very popular way to own property that isn't owned by a married couple, or it isn't a property that they live on, because tenancy by the entirety is limited to their home where they live, and that's joint tenancy. Joint tenancy is very similar to tenancy by the entirety in that it has that right of survivorship aspect to it, that if someone passes away, the other automatically gets it. And as you know, John, we've done many transactions with people that are in a committed relationship, but they're not married. They're not legally married.
Right.
And that's a conversation that I have with them about, are they willing to put it into a form of ownership where there is this automatic right of survivorship between them, or do they want their portion, which is typically a half, to go to their family if something happens to them and not necessarily to the other owner. So marriage.
That's a really interesting scenario. So you've got a married couple, they're going to probably take title and tenancy by the entirety. Tenants by the entirety, is that correct?
Correct, that's correct.
But if they're just living together and they have, say, a equal interest in the home, 50-50, but they're not married, that's when they would take it as joint tenants?
Well, they would have to be, if they wanted the right of survivorship, the only option for them is joint tenancy, because they don't qualify for tenants by the entirety because they're not legally married. You have to be legally married to use that form of ownership.
Okay, gotcha.
And so then they could be joint tenants. And truthfully, most of the time in that situation, the parties do choose to be joint tenants. But there have been situations where one or the other of them acquired the money for the down payment from their family, and they don't want something to happen to them, and all of a sudden automatically it goes to the other person, and that person may not honor the fact that the other family was the one that came up with $50,000 or $80,000. So in those situations, they do take title in a manner where there isn't an automatic right of survivorship, and if they were to pass, their half of the ownership would go to that family that provided them with the money, so that interest in the property can be protected that way. So everything is unique. Every deal, as you know, has its own set of facts and circumstances and is a unique situation.
Yeah, so I think it sounds to me like the best way to approach it is when deciding to purchase a home, given, a person would want to look at their specific situation, talk to you, figure out based on their situation, married or unmarried, whether or not they'd want to put the property in a trust. All these things are questions that a consumer wants to chat with you about when purchasing a home, so that you can give them the best guidance there on which way is the best to take title. That's interesting what we've discussed. Just to wrap the title discussion, talk a little bit about why I would want to put my home in a trust. If I owned it, what's the point of putting it in a trust?
Well, sadly, every one of us is going to eventually pass away. And The problem is we just don't know when. And we have expectations that we're all going to grow old, but sometimes things happen unexpectedly and tragically. And then it leaves a real mess, especially when you have young children or children that aren't the age of 18 yet. And what's going to happen, because legally, if a husband and wife were in a car accident and they both passed away, okay, the ownership of that property would go to their children, but their children might be 6, 10, and 15. And so, it's going to have to go through probate, which is a fairly expensive and takes at least a year on average to conduct. And then, because the kids are underage, they have to open up what's called a minor's estate. So more court procedures and expenses go into that, and that money gets held until they turn 18. They don't get the use of it. And if they need it for some emergency situation, they have to go to court and ask the judge for permission to get some of their own money for whatever purpose. And my experience with these kinds of things is that the judges are very conservative, and they want to hold on to that money for as much of it, and they're very reluctant to let you use it unless it's like a really, really emergency and medical type of reason. So why go through all that when you can put your property into a trust so that it passes automatically on to your children? It's beyond the husband-wife or the committed relationship thing, where if something happened to them, what about the children? And you, like we said, we have other situations. What about older people who get into second marriages, but they have children from their first marriages, and they don't automatically necessarily want it to go just to the husband's children or just to the wife's children, because by law, that's where it would go. If the husband dies and there is no automatic survivorship thing, it would just go to his kids, and he might consider the wife's kids to be as much of their kids as his. So There's got to be a way to get it there. And the best way to do it is through a trust, because trusts avoid probate and can handle the money while the kids are underage, if they are, without having to go through all the court rigmarole. And the trustee then has power to spend that money for legitimate reasons on the kids as they need it, and then can give it to them. And you can delay the process of them getting the money, because 18 is a little too young to be handed, $250,000. You might not be mature enough to do all the best things with it.
Right. Okay, so that's a lot of good information. I think my conclusion with regard to title is there's several different ways you can take your home in title. There's several different options. And I think kind of makes me feel like each person's kind of in a different situation in life, and with marriage, with divorce, with new relationships. So all these factors come into play when deciding how to take their home in title. So, okay, for everybody out there, we're going to go ahead and wrap this conversation on title, but certainly call me if you have any more questions. We can get you specific answers for your situation. Call Steve if you have any specific questions with regard to title as well. He can help guide you as to what will be best for you to do. And again, I'm John Weslowski, co-lead agent of the CT team at Baird and Warner in Naperville, Illinois. And
Steve Shaykin. Best way to reach me is on my cell. I give all my clients and real estate agents that I work with my cell, because I can be found pretty much 24/7. It's 224-595-1216. My email is Steve
at Shaykin.com.
Steve at Shaykin.com, SHAYKIN.com. So thanks for listening, everybody, and have a great day.
All right. Take care, guys. We hope to hear from you soon.
Follow us for more updates.